All rise. Court of Appeals Division 1 is now in session.
Please be seated. Good morning. We are here today in Wednesday, CV 140837 is Horn versus Polk. As you may notice, Judge Thompson is not here on the bench with us today. He planned to be here, and he was on his way back to Arizona from Colorado, but his plane was delayed by weather, so he can't be here. But nevertheless, he is involved in the case and will listen to the recording of the argument. Each side will have 20 minutes for argument. Apparently, you may reserve any portion of the time for rebuttal, but you'll have to keep track of your own time. That's why we have a clock at the podium. As I said earlier, this argument will be recorded, so you'll be able to watch the argument on YouTube in a few days. We have read the briefs and the record, and we've conferenced the case, so we are familiar with the facts and the law and the record. So when you begin your argument, just launch right into what you think we should know. And because it's recorded, please identify yourself and your client when you begin your argument. Counsel, you may begin.
Thank you, Your Honor. Your Honor. I would like to reserve 10 minutes, and Mr. Lasota, who is Ms. Wynn's attorney, will argue 3 of my, hopefully, 10 minutes. Your Honors, we start with page 35 of the response brief because there, stuck in a footnote no less, is a critical admission that the county attorney individually was involved with the prosecution of this case by assisting with its preparation and its strategy. And that only came, as I say in the response brief. All of the cases in all of the jurisdictions, some of which are summarized on the board that I've got here, you have all these cases in our briefing, hold that an agency can investigate or initiate investigation of a charge and later pursue and decide the case as adjudicators, but only if the individual final decision maker is walled off from the adversary process itself so as to ensure a fair hearing and a fair tribunal, which comports with notions of fundamental procedural due process. Because
don't the cases suggest that that to disqualify that individual, you have to actually show some actual bias or partiality?
No, Your Honor. There is not one case that deals with our situation here, which deals with a prosecutor who ultimately chooses to usurp the process and make the final decision, becoming the adjudicator when she herself is involved in the prosecution. All of the cases that I've reviewed, and they haven't cited anything to the contrary, by the way, really deal with different circumstances, as I say, that deal with more of initiating at most investigation and then making adjudication, which is permissible. So in those situations, I would contend the rule here should be that in those limited situations, even one would have to show something more. Excuse me, some personal, I'm suffering from a little bit of a cold, some kind of a personal bias or interest beyond that of just being the prosecutor, because that purports bias by itself. If I were to rule in this case for myself, that purports obvious bias and prejudice. So that's why I think the rule should be, to cut to the chase, the rule should be that where there is investigatory function. And by the way, in Rouse, for example, there wasn't even that. It was a school initiating and a school board ultimately deciding the case that they rely on. But even in Withrow, the other case that they rely upon, there's no prosecutory or adversarial participation.
The statute itself creates the ability of the head of the agency to accept, reject, or modify the ALJ's decision.
Correct.
Is it your view that if the head of the agency has merely blessed the investigation and the adjudication proceeding forward, or the prosecution proceeding forward, that is a disqualifying fact?
No, and as I said, I think being involved in merely the efforts to initiate the investigation and a final adjudication courts have held is permissible, and I think that should be the holding of this court as well. We're not here to upset the apple cart and turn the entire system on its head. What we're saying is that there is no case in any of the cases that have been cited, no case that finds that it is permissible to be involved as a prosecutor in the advocacy of the case and adjudicate your own case. And that is the distinction. So Title 41 contemplates, in my opinion, a fair and impartial judge in the end who was walled off, individually walled off, from the actual participation in the planning and strategizing of the prosecution itself.
Was Ms. Polk an advocate here?
Absolutely, Your Honor, and that's why I say page 35 of their response, for the first time admitting that, which frankly should have been admitted long before then, to be candid. But for the first time in page 35, it's a bombshell, because there she admits that she was involved in the, quote, preparation and strategy of the prosecution, essentially the eminence grise behind the scenes who is conducting the prosecution and then choosing to hijack the result after the ALJ heard the credibility and demeanor-based testimony of the witnesses to basically suit her own prosecution. That is completely a violation of fundamental due process in any way or shape.
And you made this argument to the Superior Court?
Well, we couldn't make the argument in full, Your Honor, Judge Howe, because, as you note, as I said, page 35, we made the argument in part, which is in our opening brief. So we make the argument. What we didn't have at the time was page 35, which cements the argument, because what we didn't have then, and we of course couldn't have, was evidence going behind the curtain and determining what exactly Ms. Polk, who was the final decision maker's personal involvement was in the prosecution. We did get that, as I say, as a bombshell on page 35 stuck in a footnote. And that ends and seals the deal, because once she has admitted to being involved in the planning and strategy, the game is over, because the cases, all of them, stand for the proposition, as I said, none of them, let's put it that way to start with, none of them stand for the proposition anywhere in the country that they've been able to cite and that I've been able to find would advance the proposition that an advocate, someone who participates in the direct advocacy and prosecution of a claim, can then later be the final adjudicator. And this is particularly egregious in this case. And as you'll...
Well, I'm sorry, counsel. So if in your view, the county attorney herself were not involved in the prosecution of the case other than as a head of the agency prosecuting the case, then you believe you would lose?
Well, I believe it's correct to say, Your Honor, that if she had walled herself off from being personally involved as the final decision maker, that would probably be, to get back to Judge Winthrop's point, probably permissible under the law, because that happens a lot in our state. But as you know, we have solicitor generals who separate functions, and the final decision maker of the agencies has someone else prosecuting those cases from the AG's office. That's the way it's done, and the reason it's done that way is a good one. And all we're asking the court to do today is to basically put that in writing to make it clear. That's why this case is important, that those lines cannot be blurred, because once you step over that line, once you cross over from being from an advocate to the judge of the case, there cannot possibly be under any scenario anything but prejudice to you, because, as the courts have pointed out, prosecutors want to win, and it doesn't allow, in common sense, for somebody to basically just disagree with credibility-based determinations. These were credibility-based determinations, as they have admitted in their brief, I think page 24, that were central to the case, that the ALJ witnessed the demeanor of witnesses. That's why it's important.
Well, counsel, the argument, as I understand it, from the county attorney is that that the county attorney's decision was based on reviewing the record and not on any credibility determinations in terms of demeanor.
Your Honor, they may say that in their briefing, but they also say that at page 24 that Horn and Wynn's credibility was central to the case, and the admission that they're basically overruling the administrative law judge's credibility findings because there was no direct evidence that they had. All they had was a couple of emails that don't mention Mr. Horn, don't mention coordination.
Well, but Counsel, I'm trying not to slice things too thinly, but what the ALJ can look at that the county attorney could not read, of course, cannot, is a demeanor of the counsel, but the demeanor is only one aspect of overall credibility, and I take it that you can have witnesses who appear very credible on the stand, but when you actually look at the evidence, they're not credible at all. If you look at the entire evidence and just know that they're just demeanor.
Well, Your Honor, to answer you simply, we've cited cases, as you know, Caden, which is a Maryland case, but it's pretty close on point, and Newman, which is just another one of the general cases that find that credibility determinations are critical. The courts of appeal very rarely will overturn them. In this case, the ALJ was there. She witnessed witnesses where there was no direct evidence that they provided, except we had the only direct evidence, which was a notification on October 19th to Mr. Horn, in which he was notified the day before the critical conversation that they chose to bring out that he was going to have to come up with significant funds in order to complete his 1031 exchange, which was the reason why he was contacting and talking to Ms. Wynn. Where there are two reasonably plausible inferences to be drawn from the documentary evidence the ALJ found, since that is what her finding says, where there are two reasonable plausible inferences to be drawn, she drew her final inference in her ruling based upon that credibility-based determination of listening to the witnesses. And the only witness they had, the FBI agent, she found to be incredible. So that was the basis for her ruling. I would like to reserve time.
Let me ask one last question before you go, because I want to get back to the statute. The statute in question here,
41.
1092.08, doesn't say that the agency head should defer to credibility findings by the ALJ, does it?
No, it doesn't.
In fact, it authorizes that agency head to accept, reject, or modify those findings in any way he or she sees supported by the record.
Sure. But where there is no direct evidence and where the only evidence was circumstantial and there's only one inference to be drawn from that evidence, we believe the ALJ gets to make that determination and did make that determination. And someone who's not present at the hearing, and again, who is bogged down with this taint of prejudice based upon the fact that she is, in fact, the advocate as well as the final decision maker, Title 41 really can't address all those issues, but that's the facts that we have here.
I understand your point.
Thank you.
Thank you, counsel.
Appreciate it.
Good morning, honorable members of the panel. I'm Timothy Lasota. I'm appearing on behalf of Kathleen Wynn. And, Your Honor, that was a good lead-in question on Title 41 because I'm going to talk about that for a minute. And I would start with the proposition that a right that can be taken away so easily as has been done so here is not a right at all. And I say that because Kathleen Wynn clearly had a First Amendment right to engage in express advocacy. I don't think that is disputed. And so we get an accuser who said that right essentially should be eviscerated because of a claimed violation. So We've got an accuser saying that we're going to essentially take away that right because she did something wrong. Now, where is Ms. Wynn's ability to challenge her accuser? We're still trying to find that. So we go through the administrative process. We go through a lengthy administrative hearing in front of a judge and find out after the fact that that doesn't mean a thing because the Yavapai County Attorney's Office simply overrules the administrative law judge. We appeal to Superior Court, and that judge says, well, you know, I've got to sustain this if there's any evidence to support the agency's decision. That's the review we get from the Superior Court judge. And I would submit...
The law, isn't that what the law provides in terms of a standard of review?
That's Title 41 administrative actions. That essentially, there's some question about whether it's substantial evidence or whether it's any evidence, but
well, I think
I would agree.
Under the Gavick case, it's substantial evidence that supports a view, if I remember that case.
Your Honor, they've said both at different times, but I would submit to you that regardless of the standard, this is not consistent with First Amendment rights. Having an agency being able to make a decision that you're never essentially able to challenge in court. I mean, let's take the standard. They've said over and over again, Yavapai County Attorney's Office, our standard was preponderance of the evidence. Well, who did they meet that burden to? Their argument seems to be we get to decide as Yavapai County Attorney's Office whether we've met our own burden. That's not a burden at all. And I would submit that this is completely inconsistent with what the U.S. Supreme Court said in Bose v. Consumers Union, where they said in cases of First Amendment rights, we need to exercise enhanced appellate review. And in that instance, they said, you know, you have a federal rule of civil procedure that says in order to disturb the trial court findings, you have to, it's a clearly erroneous standard. And in that case, the U.S. Supreme Court said, we're not following that standard in this case because this case is different. This is a First Amendment case. So it's the same here. I mean, what's happened here has been the exact polar opposite of enhanced appellate review. I mean, this has been no appellate review. It's been one agency making a determination, us not having any meaningful right to challenge that determination, and then we go to Superior Court and the judge quotes Title 41 and says, well, yeah, and some case law and says, if there's substantial evidence, any evidence, whichever it is. But Yetman v. English also said the same thing. That's an Arizona Supreme Court says rigorous scrutiny, quote, is required by the First Amendment at both the trial and appellate levels. Well, where's the rigorous scrutiny? This is not rigorous at all. In fact, it's extreme deference to a single agency head. And I would submit that that is just not in keeping with First Amendment rights. We're still, and again, I still go back to the question, where did they meet their burden? They didn't meet it in front of the ALJ because she ruled against them. They didn't meet any burden other than this substantial, extremely deferential burden to the trial judge. So, you know, it's the Yavapai County Attorney's Office position essentially that we're not going to get a real day in court. And I would just ask Your Honors that you not accept that position and you provide us with the opportunity to vindicate our rights in some forum that doesn't require us to essentially rely on what our own prosecutor, our own accuser decides. With that, I'll stop so I leave some time for rebuttal.
Thank you, counsel. Counsel?
Is this yours?
Oh, thank you.
Thank you, and may it please the court. My name is Benjamin Kreutzberg. I'm a deputy Yavapai County attorney, obviously representing Ms. Polk. With me at the table is Tom Stockson, the chief civil deputy of the county attorney's office. Two fundamental points shape this case and today's argument. And the first is that the statutes make this an administrative process. The Yavapai County attorney, acting as agency head, rejected in part some of the ALJ's findings. But that is only one piece of the much larger process. The ALJ hearing fundamentally provides an opportunity for Mr. Horn and Ms. Wen to present their facts and argument. They had that opportunity regardless of the subsequent administrative proceedings. There's no claim that the agency did not properly follow the administrative statutes in Title 41. And if their application to this case is truly unconstitutional, then all manner of applications of the administrative statutes must necessarily be in question.
Well, in this case, counsel's essentially arguing that the agency and its head hijacked the due process afforded by the statutes and should be disqualified from having the ability or the authority under Title 41 to reject these findings. What's your response to that?
Your Honor, the fundamental concept of this combination of roles is inherent in the Title 41 statutes and is inherent and sustained in a large body of case law, both Arizona and throughout the country. This idea that absent any requirement in the statutes, we're going to require the Yavapai County Attorney to wall herself off in a campaign finance enforcement hearing, it's really injecting another element into these statutes that is not there. It is not required by the case law. The second fundamental point about this case is that the core facts shown in the documentary evidence, those core facts, although admittedly not the inferences derived from them, are undisputed. Mr. Horn and Ms. Wynn had conversations at precisely the times that Ms. Wynn stated that she was receiving guidance from her several masters, in her own words, and others.
Okay, so I have a question about what we were discussing
Sure.
Previously. From my prior experience with the Attorney General's office, I understand that agencies both prosecute cases and decide the cases, but this is my understanding that they have separate counsel, one to assist in the prosecution and one to assist in the decisional process. So it's divided, and very often the Solicitor General will handle matters so the AG, who is the ultimate agency head, is walled off. Why shouldn't that be the procedure when you have cases like this?
Well, Your Honor, there are a few reasons. First is that it's not required by the statutes or the case law. It is, and I agree, I've heard of that process being done. I don't work for the AG's office, but I believe that it is done. But I don't think it's required. Another important concept is that sometimes the agency head is very important to the process, to the administrative process. Regardless of whether the Yavapai County Attorney's Office has these sort of specialized skills and knowledge, which we take the position that the Yavapai County Attorney does, they take the opposite position. But if there are these sorts of special skills, then the agency head might be exactly the type of person who would need to be involved to get the best possible progress through the administrative process. And in this type of case, where there's a political, a quasi-political type of situation, we have an elected officer pursuing a campaign finance proceeding against another elected officer, it would be very difficult for an elected officer to turn that over without any sort of oversight. Fundamentally, when we look at this, the agency head rejected part of the ALJ's decision, but the agency head did not interfere with the underlying process. She was not present at the hearing. There is that footnote in our brief, and that is absolutely the case, that Ms. Polk was involved in sort of a supervisory capacity, but there's not the same sort of direct involvement. This was not the case of an attorney, making an objection and then ruling on the objection in open court. It was a separate step and a later step when the agency head was able to reject some of the ALJ's conclusions.
Are you conceding that if that were the case, that would be improper? I
wouldn't necessarily concede that it's the case, because the statutes don't require that level of separation. and I don't think the case law does either. There's even some support in the case law from the if I can find my citation, from the Comau case, a direct quote from the opinion, an overlap of investigatory, prosecutorial, and adjudicatory functions in an agency employee does not necessarily violate due process. And I think that is dicta in that case, but there's an understanding that these sorts of things need to happen for the administrative process to work. Most fundamentally, the law in Arizona, as described in cases like Rouse, Pavlik, Comau, as well as federal cases, is that this combination of roles is acceptable. Another important point, and a case that I would point the court to, is the Rouse case. And the specific point I'm driving at is that the Rouse court made it a very important point that the agency roles and defined procedures were in the statutes. And that's the same situation we have here. Title 41 allows the agency head to have these adjudicatory powers and does not require the agency head to wall herself off. The Pavlik versus Chinle Unified School District case stands for the proposition that actual bias is required, and also that bias must be more than mere attorney's fee exposure. That also would translate into more bias being required than some sort of peripheral involvement with an earlier stage of the proceedings, particularly when the ultimate decision, the ultimate administrative decision, is a separate stage of the proceedings rather than the hearing itself. The case law cited on the board and throughout Mr. Horn and Ms. Wynn's brief, the out-of-state cases are simply not applicable. And most of the cases that describe this sort of problematic combination are in a different set of facts. They're a single person or people from the same office engaging in advocacy and adjudication at the same hearing. Here we have that separation in time and separation in procedure between the actual hearing and the final administrative decision. The final administrative decision is what is reviewable by this court. The ALJ process is just a mechanism to develop facts and law to get to that administrative process.
In this case, counsel, as I understand Ms. Polk's taking exception to the ALJ's decision, she found certain factual findings were not credible because she was looking principally at the documentary evidence that was in the record. I mean, it's the same documentary evidence that was in front of the ALJ along with the witness testimony, wasn't it?
It was, Your Honor.
I mean, why isn't this the classic, we defer to the person who got to see the witnesses and how they reacted when questioned about these documents and determining credibility?
The core factor there is whether the ultimate decision, the agency's decision, is based on determination of demeanor. And the agency head and the ALJ both got to look at the same documentary evidence, as you indicate. That documentary evidence contradicts what the testimony is. So it ultimately doesn't matter. Anything that could be observed from the demeanor couldn't possibly overrule the objective documentary evidence. I mean, if we take this idea that deference is required to all ALJ findings, then it would never be possible for an administrative agency to overrule or reject an ALJ's findings based on any testimonial evidence, no matter how strong the documentary evidence would be that contradicts that testimony.
Well, if that's the case, I wonder why there isn't a hearing before the ALJ. Why doesn't the agency head make its decision if it gives no deference?
Well, the purpose of the hearing is to provide an opportunity to present the facts in the law, to develop that record. And then once that record is developed, then that record also provides an opportunity for judicial review. The court, the Superior Court, has the opportunity to look at that record, analyze it, and determine, based on the documentary evidence, as well as the same sort of transcript type testimonial things that the agency head could look at, and that provides another layer of due process. The Pavlik case indicates that this opportunity to present new evidence, or at least the opportunity to have judicial review, is important to having a sustained, a due process consistent situation.
Counsel, are you saying that the demeanor of the witnesses is just a minor part of the overall credibility determination that's ultimately for the agency head to make?
I think it is for the agency head to, it's the agency head's power to resolve the final issues based on whatever evidence is appropriate. As to the level of deference for the, not the level of deference, but the level of importance of the demeanor-based assessments, it depends on the situation. If the evidence, if the documentary or objective evidence is massively strong and the testimony is in conflict with that, then yes, I think demeanor-based assessments are relatively small. I would point the court to the Caden, Ring, and Seal case, which is cited by both courts, by both sides, and it distinguishes between resolutions of fact based on testimony and resolutions based on drawing inferences from and weighing non-testimonial evidence, which is really what happened in the agency's determination. And that's what's relevant. It's not the ALJ's process that's being reviewed. It's the agency's determination that is before this court.
Well, which raises the issue that Mr. Lasota brought a few minutes ago, and that is the burden here. He contends his client was expressing her First Amendment rights to express advocacy, and that should change the way we look at this. I'd like to know your response to that.
There's certainly law that when you have First Amendment rights, there's a sort of heightened scrutiny to a degree, but that doesn't mean that we have to throw out the procedure or increase the burdens on the agency. It just means that we have to actually prove something. And the answering brief describes how the evidence shows that this sort of coordination happened. The First Amendment challenge here would really be to saying that this sort of, expression isn't constitutionally protected or is constitutionally protected. It's not this concept of what the facts being proven are, what the underlying facts that happened are. Those need to be established by whatever mechanism the law sets, and the law sets the process of going to the county attorney or attorney general's office and then review through the administrative process. Another important procedural point about this concept of the agency and rejecting the ALJ's determination is that the agency could have appealed the ALJ's determination had it become the final administrative judgment, the final administrative decision. And that puts this case into context. The ultimate issues are the same regardless of the procedural posture. And if we were here on an appeal from the ALJ's decision, the only difference would be which side would have the burden of overcoming that administrative decision. But this court can still look at the record and the facts and determine and decide whether those facts support whatever standard of review is applicable. I'd like to briefly address the constitutional challenges to Arizona's campaign finance laws. There's the discussion of Randall versus Sorrell and the Arizona campaign finance limits. The fundamental point there is that Arizona's contribution limits were considerably higher than the limits in Vermont that were rejected in Randall versus Sorrell. And Randall also specifically rejected the sort of rigid per capita counting type analysis that Mr. Horn and Ms. Wynn embrace. A direct quote from the opinion: campaign costs do not automatically increase or decrease in precise proportion to the size of an electoral district. And extending that analysis, Mr. Horn and Ms. Wynn's analysis, would lead to an absurd result. It would imply that California's citizens would be entitled to contribute 5 times as much as Arizona's citizens just because of California's population. and over 50 times as much as Vermont citizens. And that highlights why per capita counting is not a very good analytical tool. If there are larger states, there are more people to reach in a election communication, but also more people to raise that money from to reach those dollar thresholds. Randall also identified a number of other factors, and the answering brief describes how they all support the Arizona limits constitutionality. The fundamental point there is that Randall does not stand as a bright line rule that Arizona's campaign contribution limits are too low, particularly without any sort of expert analysis. With that, I would be happy to answer any other questions, but otherwise I would ask that this court affirm the judgment of the Superior Court.
Thank you, counsel.
Thank you.
Rebuttal?
First of all, let me hit a couple of points here. Sheila Polk has no expertise on credibility, and certainly no more than the ALJ did, who heard the evidence. Second, case law is absolutely clear, and they've cited nothing to the contrary to what was just stated. Third, we had the opportunity to present our evidence, and we did, and we won. That should be given deference to. Nothing in Title 41, contrary to what was just said, would condone this kind of activity of a prosecutor deciding her own case. There doesn't need to be anything in Title 41 on that because fundamental due process requires it. Case law is all to the effect that this is improper. Every case that's been cited, including Rouse, which was distinguished in R.L. Augustine, and Withrow, which was distinguished in the Gila case we cited, which basically said there's nothing remarkable about Withrow and there's nothing remarkable about Rouse because neither of them dealt with advocacy and an advocate deciding, as I said, to hijack the process and decide her own case because she didn't like the decision of the ALJ. So all the cases stand for that proposition. Furthermore, the documentary evidence here does not contradict, as was stated, anything testified about at all. As I said in my original remarks, there's nothing in any of that documentary evidence that supports their case. It all has to revolve around circumstantial evidence, which did not lead to one inescapable conclusion. As the ALJ found, there were two reasonable inferences, and she believed, based on the testimony and also on the incredibility of their witness, the FBI agent, she believed Horn and Wynn were telling the truth, that this had to do with a completely unrelated transaction, and that should be given deference. The documentary evidence establishes nothing to the contrary, and ultimately, where there are two reasonable inferences, they had to produce some affirmative direct evidence. They produced nothing direct or affirmative. The only evidence, in truth, that was produced, as I said, in a documentary capacity that supported our position was the document that I referenced, which was showing that Mr. Horn, the immediately day prior to the conversation of the 20th, had to raise significant funds, and he talked to his friend Kathleen Wynn because she had experience in that area and took down an application for him. There was nothing to contradict that. Those are the facts. So credibility determinations are rarely reviewed by the Superior Court, which makes this all the more important. Those credibility determinations, contrary to what was stated, were found in our favor. The agency decision is totally and fatally flawed, leaving the decision of the ALJ to be final under Title 41, the statute that was cited, because the ultimate decision needs to be reversed, leaving within 30 days that decision becomes final and was final. Thank you. I'm going to reserve the time for my colleague. I'm sorry.
Okay, just a couple quick points. Mr. Kreutzberg admitted that there is heightened scrutiny in a First Amendment case, and whatever standard the trial judge applied, whether it's abuse of discretion, any evidence, substantial evidence, that is not heightened scrutiny. That is deference to the agency. We're still waiting to see where this heightened scrutiny is going to come about. Now, Mr. Kreutzberg also said, well, you know, you got to present your case, you got to develop facts, you got to the ALJ. Well, that's like saying, here, yeah, present to this jury here, we're going to give you your day in court. You present to that jury for 4 days testimony and documentary evidence, and then when it's time for the decision, they say, oh, no, that jury's not going to make your decision. We're going to bring in a new one. And by the way, they work for the other side. That we never had this opportunity. We've still not gotten our day in court. And this is just not consistent with First Amendment protections of the right to free speech. It talks about heightened scrutiny. There's been extremely minimal scrutiny. So with that, I would ask that you reverse the trial court's ruling. Thank you, Your Honors.
Thank you, counsel, for your argument today. We'll issue a decision in due course. We stand adjourned. Thank you.